All right, welcome everybody to this edition of Expert Witness with Doug Miner and Steven Palmieri, minus the key ingredient of Doug Miner. He is out, I believe, at work expert witnessing right now, but we do have special guest James, the arbitration coach, Wilhite, coming in today as our special guest here at Expert Witness. James has a niche skill that he has learned. He's taken his desire to beat the bad guy, and he beats them at their own arbitration game. James, how are you doing today, sir? Welcome. Thanks for joining us.
Thanks, Steven. It's great to be on this show with you, and I appreciate the opportunity.
Sweet, man. Glad to have you here, brother. So we met about a year ago or so in our pre-litigation community group and stuff, and you kind of have a little niche. You do arbitration. Well, so first we'll just kind of say, obviously, you're not an attorney, but you do credit repair and you do business credit. But really, your core initial skill was learning the arbitration game and kind of using that, especially against like utility companies, to try to get deletions, right? So, you got those nasty Verizon charge-offs, which, by the way, never even report accurately because it never shows you. Did you hear that? It never does show you like a complete account. They never show you any of the positive payment history. They literally just slap that thing on when you go into collection, and they're like, yeah, it's complete enough for accurate reporting. And you've kind of go in and get their contracts and find the arbitration and squeeze those guys with that. So give us kind of the high level on, how did you get into figuring out the arbitration game?
Yeah. So I had worked before I had started my credit repair business, I had worked with an attorney and worked in his office just doing like administrative things. And he kind of took me under his wing, and he doesn't practice consumer law, actually. It's just criminal and immigration law. But he started to talk to me about the contracts. He knew I was repairing my credit or repairing people's credit. I started just doing like family and friends, and so I started learning about like, okay, what is arbitration exactly, and how is that different from going to court or small claims, right? And I've always been fascinated with the legal system, and I started just with actually the cell phone company. Now, I think a lot of people deal with specifically the telecom companies having issues with them, and I can remember for myself, maybe about 10 years ago, I had canceled an AT&T account, and then I got charged for another extra month of service, which ended up going to collections and going on my credit report, right? And at that time, that was like 2011, I just paid the collection company, right? And they removed it, and I was so sure that I didn't owe that money. But being unaware of how credit reporting works, and certainly of arbitration, I just paid the fee and went on about my way. But so I learned, fast forward a few years ago, started learning, okay, how can I help these clients with these cell phone companies? They're having issues with the cell phone companies. So I started to test out sending in my complaints directly to AT&T and Sprint and those guys, and got some responses back, which led to me negotiating with their attorneys on settling these issues and getting them removed off the credit report.
Okay, so when you say you would send your complaints over to them, like your disputes and stuff, so was this a complaint, a dispute, where you're like telling them, hey, here's a copy of the contract and we're going to arbitrate? Like, what did these dispute complaints look like that you were sending over there that was raising the eyes of their attorneys?
Yeah, so I would take, in the beginning, I would take just very basic language, like very like just as a lay person, this is my complaint, this is what happened, and I would send those letters in certified mail to a corporate address or a legal department to these big companies. And it was just very basic language, it wasn't saying anything about, consumer laws or the credit reporting laws or anything like that. And just kind of, they were kind of rants, to tell you the truth, just like ranting, and that's where it would begin. And then they would contact the client and propose some kind of resolution. And
so
those
you got
are very,
a power of attorney, right? It's like you had a notarized power of attorney from your clients, so you're sending the third party type letters to these.
not in the beginning. Yeah, not in the beginning. I use a power of attorney for my credit repair company now, but then it was just I would send the letters on behalf of the client, and then they would contact my client, and I would just sort of do. I would just like coach my clients basically on what to do next.
Yeah.
Yeah.
So okay, so you're over here. So it all started. They did something nefarious to you. They tried to charge you for an extra month. You got that worked out, and then you saw a business model, and you started helping clients, sending letters to these people. At what point did you realize the whole arbitration part? Because your initial letters, you said you just kind of sent plain old letters to these executives complaining, and they would contact the consumer. You weren't really using the arbitration leverage at that point. Is that correct? Not initially?
Yeah, not so much. I knew from the training I got with the attorney that there was. I did understand some basic things about the arbitration process, and like what it would cost. What were the costs and the fees involved in arbitration, and what was the timeline like, generally for arbitration, and no, so I did know how much it would inconvenience these big companies if I went through it.
Yeah, so that's the real thing, is the inconvenience. Okay, so let's fast forward to where we are today. Do you do the arbitration credit repair tactic mostly with utility companies still and cell phone, or do you do it for like credit card companies as well? What is the scope of how
I do it with the credit card companies, and I do it with now I've got enough data, I feel, on some of the big credit card companies. I know what their play is going to be. I know if they're going to be willing to work it out, or if they're just going to fight it all the way. And of course, none of them assume responsibility ever. Even if it's like really, if it really was a messed up situation or something, like really bad. And I've seen some really bad, like heard some horror stories. They're never going to admit that they did anything wrong, so don't expect that. But yeah, there's I do it with the credit card companies and with the telecom companies, and then I've done some other kind of not related to credit repair, but just consumer items like large chains of gyms or gymnasiums, whatever you want to call them, fitness centers, Airbnb.
So what are some of these nasty credit card stories like that you said, there's some really where the consumer clearly got done wrong? Give us kind of an example of what you've seen and what you've worked on.
Yeah, well, the first one that comes to mind is the telecom companies. And with the credit card companies, it's a lot of times it's just the misreporting. Credit card companies, I'd say Wells Fargo. So Wells Fargo, I have one client that had a checking account. He also had a credit card, and the credit card, the checking account. Okay, what happened here? They shut down his credit card, and then so what happened? Sorry, this was okay. He had a checking account, credit card. He went over, I think, on the checking account. So oh gosh, dude, can't even think of it now.
It was so bad you permanently blocked it out of your memory. That's how bad Wells Fargo was.
It was bad. But the guy had they shut down one of the accounts, and then his online access, like you can pay your bills online, right? Well, they only gave him access to one of the accounts. Then they had a representative follow up with him. Hey, when did you pay this bill? It was either an overdraft fee or it was something on credit card. One of the two. He had missed a payment, so they shut down one of the accounts, locked him out online, so he couldn't pay the bill. Then the guy like he couldn't get online access again. And then it ended up just snowballing into like the guy having to borrow money because he had couldn't get access to something. It was messed up, dude.
So were you able to resolve it with arbitration? How did you get through that situation?
Yeah. So finally we did, and it was sometimes Wells Fargo, they will settle quickly, and then other times it seems like they will drag it out or they will fight. And that may just be depending on who because they use outside counsel, so it may just depend on who's working the case. But they did end up settling, and they did remove the account from his credit report. They were claiming that he had owed some money on this credit card, and which he didn't, and they wouldn't provide the documents whenever we requested all the statements and everything like that. So we didn't have to go through the entire arbitration process, but they did delete the account, and they paid him, a small fee.
So let's talk a little bit about what does the arbitration process look like? How does that go from start to finish?
Yeah, so I have to say that the goal is never to go through the arbitration process. I call it the pre-arbitration process, similar to your pre-lit. I mean, I don't want to actually go through the months of, being either on video or over the phone with an arbitrator and go through that whole process, which will take months, 4, 5, 6 months. I just want to get the client made whole and get the account deleted, get my fee, and move on, right? So, you always start with a dispute. You got to have a dispute that you send in, and always certified mail, right? You want to keep records that you're, trying to resolve this, and that you're letting them know. So you send your disputes in, and then you wait to be contacted. Basically, there's someone that's going to reach out to you, and there's a few different ways that I do the disputes now. I mean, you don't ever just file for arbitration. Most of the agreements between you and the credit card company or whoever the company is, you do have in the contract that you're going to allow them time to resolve this before you go through arbitration. Sometimes it's 30 days, sometimes it's 60 days. You have that agreement with them, and you want to know that that's in the contract, or else once you get to that arbitration point where you're filing, you don't want it to get thrown out because you didn't follow, you're part of the contract.
You know why they're throwing out your disputes? Because you're not using that fancy new Palmieri system software. If you had that Palmieri system software, your disputes would be ironclad. But okay, I'll put that shameless little software.
I agree.
So obviously you're not an attorney, but you get the power of attorney. notarized from your clients, which is what we talk about here in the whole pre-litigation credit repair concept. And yours is pre-arbitration, which is amazing. But like you'll actually take, I guess, the arbitration, the what do you call it, the arbitration agreement? Like if you're going to file arbitration, there's some document that you have to fill out, right? And you'll fill that out, and will you send that to them and be like, hey, like here's the actual request for arbitration. We're kind of like pre-sending it to you. Like if you don't give us what we're looking for, showing you it's filled out, we're going to file it. I mean, how do you threaten these people with arbitration? Is it something like that? How does that process work?
I think you could do that. I do that sometimes. I can fill out the paperwork and attach my complaint or dispute to that, and say, hey, I am gonna do this. But most of the times it's just the letter, and you always have to start with the letter. And it doesn't have to be perfect. It's like you don't have to know the law necessarily. Like I always feel like making contact first, and then we can get into the nitty gritty once we're already in communication with each other, and they know who I am, and they know what I'm trying to do here, and then I can get more specific. So I just, I go with my intuition on it. I go with my gut, and if it's something really, again, like the Wells Fargo, if it's something really bad, then I may spend the time to.
Yeah. So there's something important here, though. Really good takeaway, is obviously you're using a POA, but you know who you're dealing with, and you're actually dealing with people. You're not just a paper mill like a lot of the old school traditional credit repair. They're kind of like paper mills, right? I mean, they'll send stuff out in what they call the first party, which is the client's name, without a power of attorney, without anything. Clients never see the letters in most cases. The recipients use their intuition and feel like they're jick-jack credit repair letters, which is probably the case if the consumer has never seen them and they've never been put on notice by a power of attorney that it came from a third party. Mm-hmm. But you're actually corresponding with real human beings. And that's an important thing to notice, because that is really that higher level of the credit repair, kind of pre-litigation concept, which is number one, dispute with the furnishers. In your case, clearly you're doing that because those are the ones that have the arbitration agreements. But again, you're not just kind of sending some little letter like paper mill. I mean, you're like, dear so-and-so, executive grand poobah of Verizon or AT&T. I'm James. Here's my POA. You're the grand poobah. We're now connected and engaged, and we're not going to disengage until something powerful and explosive happens, right? So I think that's an important takeaway, though, because you're working it like a true professional, I mean, and that's something that we really talk about here. So, have you ever had to take any clients all the way through arbitration, or do they usually resolve pre-arbitration?
Yeah, so I have gone through the entire process, and it was, this is for the most recent one was for repossession. So we should get a decision on it pretty soon. But the guy did have his car repoed, but he claimed he didn't get the letters. And of course, it's not my job to question whether he did or not. He said he didn't. And so when we asked for the documents, they provided some of them, and we don't know. We don't know if he actually got them or not. So we kept pursuing it because they wouldn't remove it based off of the inconsistencies on the credit report. Sure. And they were not. Yeah, I mean, and we tried everything. I don't always just rush into arbitration, right? Like we pointed out Metro 2, we pointed out state and federal, and we went to the CFPB as well, and nothing happened for this guy. So, having arbitration as my sort of secret weapon, oh yeah, and we also filed with small claims, and that didn't go through for some reason. I think wanted to change his mind or didn't want to go through it, but so we went through arbitration, and we did it documents only, so we didn't have to be on the phone or on video or anything. We just had to submit request documents, submit documents, and just let the arbitrator make a decision. So we should get a decision really soon on that, but I feel good about it. And yeah.
So in order for you to be able to threaten or engage in arbitration, there has to be the authority and the requirement for arbitration, which is in the original written contract, right? Because the contract will say the parties agree to arbitration instead of litigation, essentially. So through your initial dispute process, is that one of the requirements of you to, you're like, hey, I need original paperwork, guys, give me my contract. What if they don't send it to you? How do you still go forward with arbitration? Let's talk about kind of the pre-frame up there. How do you get what's required to know that you can even do what you want to do, which is arbitration or the threat thereof?
Oh yeah, definitely. I think this is really huge to I always request the documents and send that certified letter, and like with a repo or something, it's like a list of interrogatories. I ask for all kinds of stuff, and maybe I don't need to do all of that, but I do sometimes just ask for the contract, and if that's a problem, then I'll just move forward to the CFPB, or just go ahead and file the arbitration. Because
even if you don't know if arbitration is a provision of the contract, you'll still be like, hey guys, I'll plan on arbitrating anyway.
Well, I know that with the car loans and the lease contracts, those all have arbitration in them. If it doesn't, I'm going to find out. If I don't, there's a couple places you can search for contracts and see if, the company has an arbitration provision they give out to consumers. And if it doesn't, sometimes I just roll the dice and see, because there are some times where the arbitration provision is hidden. I can't get it online. The client doesn't have a copy of it. The company, they won't send me a copy of it. We don't know if there's arbitration allowed. So it's not going to hurt me to file it with, and see what happens. All they can tell me is no.
So like if you're dealing with automobiles, there's the UCC, and then you've got a 14-day response letter. You can basically ask them for a statement of account under the UCC, and they're supposed to respond to that within 14 days. Do you use that from time to time and say, hey guys, this is my 14-day request letter to you guys, send me original paperwork?
No, I don't point out the 14 days.
Well, I know, but I mean, I'm just kind of asking, like, do you use that mechanism under the UCC to try to force paperwork out if maybe you can't get it under a regular FCRA dispute?
I haven't, Steven. I think that's awesome. I mean, that's more ammunition for you to make your position about it. So yeah, no, I haven't.
And I'm going to have to charge you for all the good nuggets I'm giving you on this show here. You're going to like revamp your entire business process. I mean, because now we're talking though, we used to live here in the great Republic of Texas. You've now since moved to Arizona, but most states have Deceptive Trade Practices Act laws, state laws that make deceptive trade practices illegal. And like in Texas, you can actually send a 60-day demand letter, to anybody that basically provided a good or service to you if you believe they've engaged in deception. And I'm just sitting here thinking, if whatever state your client is in has a pretty decent Deceptive Trade Practices Act, if these companies are not providing you original documentation, that may be an avenue that you could take as well to try to compel these documents from these people. Obviously, pre-arbitration, pre-litigation, you're not making any assertions as far as you broke the law. We're just saying, we believe you were deceptive or whatever. And first of all, you're not sending us documentation to even verify we have a business agreement. So what gives, right? So, as far as your clients, like do most of them come in for just regular credit, or do you have people getting referred to you from other CROs where you're like the arbitration coach? Other CROs are like, hey, I've got this badass thing and I need you to work on it. Do you do business to business, outsource, or whatever? Like, how does who do you work with, and how can you work with our audience here who's mostly CROs listening?
Yeah, I do have some credit repair business owners refer their clients for some special cases that they think maybe I could better help with. So I do some promoting of just consumers who are dealing with the telecom companies, internet cable, cell phone service, and then like you said, the other credit repair business owners. And then I do some workshops too, and I'll just share about how to protect yourself, or like having getting your consumer disputes resolved, and those are just like free classes that I've done, like at the local community center. And
Sure. Yeah.
And that's just kind of, like I'm not, it's kind of a, because I'm not an attorney, so I'm not trying to give people legal advice, but I do want to help people. I do enjoy making money. So it's like, I give information where I can.
And you enjoy making money when it comes from the bad guy that you just stuck it to, right? Yeah, that's when you really enjoy money, right?
Oh, my credit, some of my clients, my credit repair clients, or whoever, I don't charge them any fees, and so when the creditors pay my fees, it feels really good to circulate some of that wealth and give some back to my clients, and also be compensated for it.
So will you take credit repair clients who don't have arbitratable type offenses on their credit report, or are you pretty specific as to who you onboard as a client?
No, I will. I think as a credit repair business owner, the only clients that I just invite to come back at a later time or right, or something like that, is just if they're missing payments currently in the last 30 or 60 days, like, hey, this is probably not a good fit for you right now. But no, I will help. I will help people and use that arbitration where I can.
So you say you don't really charge them. It's kind of a glorified pay for deletion, essentially, if the arbitration is paying. But if you've got somebody that clearly you're not going to be able to arbitrate, do you charge them like a monthly fee or a regular pay for deletion to do just regular credit repair? Or how does that work if you've got somebody with just a bunch of medical bills and maybe a foreclosure, but not really telecom or credit cards?
Yeah, so I do pay per deletion. And some small claims or unfiled small claims, and or I pass it on to an attorney who can better help them, because there's so many awesome attorneys that we can refer people to that'll help us. So I have to say, Rachel Kugel, I think that's how you say her last name, she's amazing, and John Watts, and of course Shiva Bhaskar, those guys make a huge difference too. So I will send them.
Another shameless plug, have all been in my training course along with you as well, the credit repair pre-litigation training course. I was going to ask you earlier, but I just need to take advantage whenever I can plug myself, because where did you learn that Metro 2 from early that you were talking about, by the way?
From the one and only.
There you go. That's right. You learned the proper Metro 2, right? The actual way to dispute it. So right. Awesome.
I have to say one thing too, Steven. That that, yeah, totally adds more fuel to my disputes. You know, pointing out the Metro 2. One thing I wanted to ask you about. Oh, sorry.
I was going to say, let's talk about that real quick, because, obviously there's, that Metro 2 compliance. We all know about that. That's kind of, the other camp out there as far as Metro 2, but they claim that that's not even really a dispute. They claim it's more of like a compliance audit or whatever. Was the information certified by the furnisher to the bureaus? And the approach that I share with folks is a little bit different. I'm like, you absolutely can actually dispute Metro 2 because it's a data format, right? I mean, it literally is their data format for reporting accurate data. So, what we use and what you're using is the Metro 2 format for an actual dispute, not like a compliance audit, but it's like, look, it's inaccurate because it's reporting or misreporting based on your own industry standard, regardless of whether the information was certified by the furnisher, right? Which is kind of what that whole compliance, thing out there that people do is, I don't care if it was certified or not. It doesn't even matter because the reporting, the reporting itself is inaccurate because, your industry standard, well, it only requires that you have one date open and there's like 2 date opens, like we see it on a credit report, June 1st and June 17th, which one is accurate? And I think that's just kind of a good distinction there, because if you're using the Metro 2 to actually dispute the Metro 2 factual disputes like that, then that opens you up to be able to then subsequently request these documents, right, from them, which will have the arbitration provisions. Because then maybe in a round 2, you're like, hey, we disputed Metro 2 accuracy. This stuff is still inaccurate. It's still inconsistent. It's still jacked. Therefore, Mr. Furnisher, please provide me with the original documentation because, well, first of all, which date is the right date open if that was your original complaint? Or, Mr. Verizon, we clearly point out that your payment history is incomplete because you literally have a date opened that's like 5 years before your first payment, and your first payment was just when it went to collection. You don't have 5 years of positive payments. So, now we need a full and complete payment history from you, Mr. Verizon, because we previously did the Metro 2 type, an accuracy dispute, which we leveraged against your industry standards. So is that fair to say that kind of the way you leverage Metro 2 and actually disputing is because it is the data? When you don't fix the data, it gives you a good reason to do a follow-up and say, hey, your data is still wrong. We need original records. Is that kind of how you're able to tie those things together?
I do. Yeah, I do. And I point out those fields, how they don't match, and how they're the ones, the creditor is the one that is reporting this to 3 credit bureaus. And how do these not match? You're saying that this client didn't made their last payment, 4 years ago on one report, but on another report it says 2 years ago. Now, for the underwriting process, this person's trying to get a loan, and it makes it can make it look like if that creditor or lender is just pulling from one credit bureau, let's say, or maybe just 2, not 3, they don't match, and how that could affect the client. That's not really where I go into. I don't pretend to know how the underwriting process works yet, but that's something I do want to learn. But it's like, how can it be fair to the consumer? And I definitely make that argument about Metro 2.
So you mentioned some of these amazing attorneys earlier, John, Rachel, Shiva. So is there a point at which, you'll kind of carry this ball and then you're like, dudes or dudettes, if it's Rachel, we need to have an attorney do this thing. What does that handoff and that process look like?
Yeah, so I haven't handed off with arbitrations. We haven't worked together yet specifically on arbitrations where, I've started one, let's say, or filed, and we're in the process already, and now they're going to step in. But I mean, what I do is, if I'm already thinking, I'm thinking ahead, of course, how I'm gonna work with them. So I do everything that I know I can do to build that fact pattern of, sending the dispute to the creditor, requesting the documents, the bureau, the CFPB, and then keeping a record of all that, those files, so that I can send them just all in one at one time to, Rachel or Shiva and say, hey, can you look at this? Like, these are all the things that I pointed out on the credit report, and here's the letters, and here's the dates, and just try and give them as much as I can without them with taking as much work out of it for them, so that it's kind of a smooth transition, and they will pick it up and work with it.
Awesome.
That's my thought.
Yeah. So let's talk a little bit about you do some coaching now, right? Didn't you just put together a training course for arbitration? Where are you taking this, into the future with your business?
Yep. So I am. Tomorrow my website goes live, and the course is going to get launched July 26th. So I want to take 20 students and teach them the process. Take a couple of months with them, 8 weeks, and go through the process of the pre-arbitration process, and really just share the knowledge and the success. I mean, it's really helped my God. I just didn't have it, in the last year or two. I don't know. I just can't imagine not having this process included in my credit repair and what I offer my clients. So I'm going to launch this course, and website will be live tomorrow. And I just want to share this information.
Sweet. And so for those students, you're intending for those students to be CROs, essentially, right? I mean, that's what your target audience is.
That's my target audience. Yep. Because a consumer could do this, a business owner, like someone who owns an Airbnb is one possible, person, who could use this. I mean, consumer advocacy, if there's something like that. But I feel like this is really geared towards credit repair business owners. This will really.
Cool. We've got Almitra. She's one of my earlier fans, I believe. Almitra, how are you? It's been a while since I've seen you. What is your web address? I know it's not up yet, right? But what will your website be?
It will be tomorrow. Yeah, it's prearbitrationacademy.com.
Very cool. Prearbitrationacademy.com. Sweet. Well, it looks like you got one fan down there, so we got Almitra. Rock on. Let's see here.
I had to share one thing with you. When you asked me about the creditor horror stories, I think this is something that all of us can, in the credit repair industry, can relate to. Is whenever COVID had started, Citi had told one of my clients that they would not report the late payments on this credit report, and they reported it anyway, right? And so we disputed it with the credit bureaus, disputed it with them. They wouldn't change the late payments, and they told them on the phone they would, right? And so we ended up settling with them, and they did remove the late payments and compensated him for his time, the issues. So that was a victory, but it really did cause some damage for like about 6 months there.
So let's talk about these nefarious debt buyers that buy these credit card debts. The big ones that we all know: Midland, Portfolio, LVNV. Those things are fun to deal with, aren't they? But if they're collecting on credit cards, which in theory have arbitration agreements, well, I mean, it's a whole other conversation whether Midland could even sue your client if the underlying contract contains an arbitration. But that's not even like for this conversation here. But the point is, do you use this arbitration against those companies with the assumption that, well, you're collecting on a charged off Capital One account, Midland, and Capital One's going to have an arbitration based on your knowledge, James. I guess we're just using Capital One as an example. But do you use it against those debt buyers as well?
Yep, I do. No, Capital One, they don't have arbitration in their. They do on the auto loans, but not on their credit cards. Um, Neither does Bank of America. But yeah, so with the collection companies, yeah, I will. So again with the telecom companies, but let's say LVNV, they've got a collection for Sterling Jewelers. This is one that I see kind of often. That contract, that original contract, whoever owns the debt is still required to honor the original contract. So, as a consumer, your recourse is you still have the ability to go to arbitration. So, yeah, I've seen a couple of things happen. I've seen where the original creditor will buy the debt back from the collection company. It comes off the collection company the collection comes off the credit report, and then the creditor says, okay, well, we're gonna, we bought it back, just leave us alone, we'll squash this, which is nice. But
so you're not talking about a debt collector where the original creditor still owns it and they just recall the debt. You're literally saying that the original creditor will purchase it back from a debt buyer that they've sold it to?
That's what they say they did. They say they bought the debt back, and which, I don't know if that's true or not, but the collection falls off and from the debt buyer, and then the original creditor says, okay, that's it.
Leave us alone.
Right. We bought it back.
We don't want to mess with the arbitration coach. Okay, just leave us alone, right?
Yeah, that's right, man. That's right. So yeah, I mean, that is awesome. And I know I've also seen some collection companies just they kind of I've had to file for arbitrations, and then they kind of don't go anywhere with the collection company. They end up getting, I'm still working this out, but some of the times the collection company will just say, well, this is not we don't have a contract with you for arbitration. So, and the collection stays on the credit report, and, there's another step to that, but that's probably a good place to have Shiva or one of the other attorneys, partner up. So, but most of the time, I feel like, yeah, filing the arbitration with the collection company or the debt buyer is gonna get the account removed at least.
Yeah. So, obviously you've got your training course coming out. You've been doing this for years, and this is the expert witness show. You've never been an expert witness yet, but the big part of it is for our audience out here. We all have kind of unique skill sets. We have some specialized knowledge that we acquire through the course of whatever we're doing. Like my co-host in the show, Doug Miner, who's not here today, but he was in the mortgage industry for years and years and years, and then he started doing credit repair, and then one day some attorney hired him to give advice on damages. And that was his very first stint at being an expert. And now he's done probably hundreds of cases as an expert. And he's like a damage expert because he was in the mortgage industry, and he did credit repair, and, he can just assess damages. So, I mean, to your extent, you've really acquired a good specialized knowledge on these creditors, kind of who does what, but also how the whole arbitration thing works, And so where, that kind of leads you to where at some point, maybe potentially this could even wind you up in doing expert work on arbitrations. I mean, if you've got these companies and these debt buyers that are suing consumers with contracts, because this is something I think some of the attorneys, I heard them talking about, I think in our training course we were talking about it. It's like, is this defense, I don't think really comes up a lot, which is, hey, debt collector, you don't even have the authority to sue me because there was an arbitration clause, right? And you just don't even really hear that very much, but it's a really true thing, right? I mean, if they're trying to collect on a trying to collect on an account that has an arbitration clause, they literally can't sue you. They have to arbitrate. So, I mean, I think there's a lot of opportunity for you to take your skill set, and potentially even carve yourself out into the legal world, because if you can help the consumer protection attorneys to help the consumers, find extra defenses against these big companies that, I mean, they'll just robo-sue people without even contracts. You've got a lot of firsthand knowledge on how these people operate. Is that something that you see yourself trying to break into down the road, is the expert arena, or do you want to just kind of stay in more just the CRO coaching and credit repair side of things?
I mean, until I had the conversation with you, I hadn't really. I do think of myself as an expert, but I hadn't thought of participating as a expert, like in some formal setting or with, not like that. I hadn't. I just, which I'm open to, and I hope to continue to grow and learn more about the process, because I mean, there is always something new that, happens or shows up, and it can be pretty dynamic, I'd say. And the pre-arbitration process alone, not even while you're in arbitration, but just like before, the conversations going back and forth with the other side. So.
Absolutely. So is it fair to say you like the arbitration trade lines more than the non-arbitration ones? Or do you like to attack them all?
I like to attack them all. Yeah, I do. I'm at the point now where I've had a lot of fun being, the guy going after, the bad guy, but now I want to teach other people. Now I want to just see other people, because I can make a bigger difference if I teach other people and they can, do the process for their clients. I mean, I did work a little bit on scaling it, but it's not as effective. I think this is a more personalized niche service.
Yeah, you've got the knowledge. I mean, you've got the skill set, the knowledge to be able to train and coach people, and do that and stuff. And so, So, back to the repossessions. I mean, are they still difficult, or, I mean, do you have pretty decent success rate, or are there certain lenders that like, dude, these people are going to fight me? I mean, because repos are always difficult to work on. How are you able to leverage this to maximum efficiency to help your clients?
Yeah. Repos are so interesting to me, man, because, man, state to state, the variances and and then, the distinction between the manufacturer and the dealership. And I've tried a lot of different things and just experiment a lot. And I think that's helped me get results, certainly. But I feel like, I mean, Ally, for example, recently, I think just like 2 weeks ago, client has a repossession, they claim, for a vehicle that he owed 44 grand on. This is in California, and we disputed it with the credit bureaus. We disputed it with them. The address didn't even. We got returned to sender. Like, the address wasn't even the correct address. I don't know if they just stopped taking mail there or whatever, but they didn't send they didn't return, send us our request for documents. But then they canceled they removed the 44 grand, and then in the comments section put something like client paid after repossession. It was so ridiculous, dude. I don't even remember what it was. Something I actually never seen before. Client paid after settlement, or paid in settlement, or something like that. So that client was thrilled because he's had a $44,000 repo on there. And when we threatened arbitration, the first step was they took the balance to zero, which is great. That was just 2 weeks ago. So now we already filed for the arbitration. So I'm certain we'll get the account removed.
So it's still a repo at this point, but a repo with a zero balance instead of a 44,000.
Right.
And
Right.
now you're filing the arbitration you filed to try to get a trade line deletion.
Yep.
Because it's not accurate to say that the client paid it, right? Because the client didn't pay it. So it's still inaccurately reporting.
Right. It's like they just like dug themselves in a deeper hole by adding this ridiculous comment to it. I mean, it's almost comical, you know? So yeah, the magic of arbitration, man. like, yeah, I'm just so proud of that result, man. I mean,
Yeah. I mean, and again, to kind of reiterate, the thing is that you're talking to real people over there. I mean, you're running your business in that open, transparent type manner. You're proof positive that little provision of the FCRA for furniture direct disputes where it says they can reject a dispute that comes from a credit repair company, which is what it says. But I've always told people, I'm like, if you get a power of attorney, you're a whole different ballgame now because you're now acting in the consumers, stepping into their for legal purposes. So, for a furnisher to get something from you, James with the power of attorney, to take that and throw it in the garbage can and say, oh, he's a credit repair guy, dude, that is a problem for those people. And, and it's one thing for me to share that with people, but, to hear stories from people like you, because, people get power of attorneys all the time, right? And so if you happen to be doing credit repair, I mean, that little provision of the FCRA was really written just kind of to give the furnishers a little get out of jail free card, because they do get so many crazy ass letters from credit repair companies that the consumers never see, and it's never disclosed to them that it came from a third party, right? And so, I can't blame them for getting that little carve out written into the FCRA. If I was a furnisher, I would want to get it put in there as well. But you're really proof positive that if you do a professional business model, you can absolutely talk to the furnishers. And so, do you do a lot of phone calls with these people, a lot of emails, mostly written? How do you engage as a POA with these people mostly?
Mostly it's through email. I mean, I prefer not to talk with them on the phone. I mean, just like, I mean, I could. I just don't enjoy it. I kind of did in the beginning, but now not so much, because I like to take my time in how I respond. And some of the attorneys, they have a legal background. They have all kinds of things, rebuttals and things that, hey, I'm not equipped to necessarily respond back to sometimes, and I'm okay with that. But through email, I can take my time. I can think about how I respond to these things, and I feel like the ball's in my court through email. And sometimes they want to get on the phone with me and talk to me, but I know they're just we're just like feeling me out, trying to get information. I understand that, so I just keep those calls. Try to keep my phone calls with them usually pretty short, and yeah.
Very cool. Well, as we kind of wrap this one up, man, it's hard to believe it's been almost an hour already talking arbitration greatness. But so obviously you've got the coaching course that's coming out geared primarily for credit repair CROs, and that is pre-arbitration
Academy.
Prearbitrationacademy.com. That should be up tomorrow, hopefully.
Yep. Yes.
They can sign up for your limited edition course. But other than that, if somebody doesn't really want to go through that, or for whatever reason isn't going through that, how can they get in touch with you or partner with you? If they have some tough cases that they want you to look at, how can you partner up with the CROs otherwise?
Yeah. So I have a Facebook group. It's Pre-Arbitration Academy, and I'm going to share some content on that. But yeah, just to connect with me and talk about what we do, talk about our business, I'm happy to do that. So yeah, people can reach me either at my email. It's james@metacreditusa, META Credit USA, or my cell phone, just don't spam me. 424-303-2330. And I enjoy talking with other credit repair business owners. You know, it's always learning something new or sharing information or stories. And so, yeah, happy to connect.
Awesome stuff. Yeah. So hopefully you guys that are watching, you know, you got some good information from this. And James, I know, is the master at arbitration. And of course, if you're watching and you want more information on what we can do to help you with just learning kind of the pre-litigation, we do have our training course. 30-day free trial, $99 a month. We've got a private Facebook group, weekly live trainings. It is fully endorsed by Matt Listro. You can just go to creditrepairtrainingcourse.com. And of course, we've got the amazing new software that we just beta released at CreditCon that'll help you generate those Metro 2 factual letters. More information there at palmierisystemdemo.com. And that being said, James, man, we appreciate you for coming here and sharing your knowledge, and we appreciate all of you guys out there in Cyberland for watching. We will sign this one off, release you guys back into the real world, and we will see all of you on the next episode.